Good afternoon. I'm Curt Levey, President of the Committee for Justice. Welcome to the latest in our series of weekly panels. This one is titled Trump Law, How the Trump Resistance Has Tried to Rewrite Legal Norms. And we're pleased to have as our co-host today the National Review Institute. NRI is a nonprofit journalistic think tank that advances conservative principles like those championed by William F. Buckley Jr. And the NRI complements the mission of National Review magazine. And I want to say thank you for co-hosting to NRI President Lindsay Craig and Miranda Bond Melvin, who's NRI's Director of External Affairs. So what is Trump law? I've been using the term for a while now to refer to a pattern where the Trump resistance to support their claim that the president is guilty of various crimes and wrongdoing have tried to rewrite the legal norms, standards, definitions across the legal landscape to the point where they've essentially invented a new body of Trump law designed to convict or hinder Trump and his allies. One of the, I think, more interesting questions is, will this apply to, will Trump law be, a one-time thing, or will it apply to other people in the future? And that's something I'm going to ask our panelists, David Rivkin, Andy McCarthy, and John Yoo. All three are renowned legal experts who will analyze the Trump law phenomena and speculate on its long-term impact. After they speak, I'll ask a few questions, then we'll take audience questions. The best way to ask a question is through Zoom Q&A function. So let me introduce the panelists in the order that they're going to speak. Andy McCarthy is a senior fellow at the National Review Institute, the folks who are co-hosting today. He's a contributing editor at National Review, a prolific writer of columns analyzing a variety of legal issues, including some of the ones we'll talk about today. He writes a new great piece almost every day. As I've said before, I don't know how he manages to be so productive. He's also written a bunch of books, most recently Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency of Donald Trump, that is. And he's also a former top federal prosecutor. Next, we'll hear from John Yoo. He's the Emanuel Heller Professor of Law at the University of California, Berkeley. He's a visiting fellow at Hoover Institution, a visiting scholar at the American Enterprise Institution. He has served in all three branches of government. He was in the Justice Department under George W. Bush. He was general counsel of the Senate Judiciary Committee. He clerked for Justice Clarence Thomas on the Supreme Court. He's written 10 books, and the latest just came out and is right on point for today's panel. It's called Defender-in-Chief, Donald Trump's Fight for Presidential Power. And last, but certainly not least, we'll hear from David Rivkin. He's a partner at the law firm Baker Hostetler, where he's co-leader of the firm's national appellate practice. He's been involved in numerous high-profile cases. He's also developed initiatives, legislative, regulatory, litigation initiatives for two different presidential administrations. You'll often see his op-eds in newspapers like the Wall Street Journal, New York Times, Washington Post. He's a frequent commentator and guest on national TV and radio shows. And let's start it off now with Andy.
Well, thank you so much, Curt, and thanks for getting the band back together. We had a great session, I guess it was a few weeks ago, and I'm delighted that we're able to do it again. And
Thanks for coming back.
Oh, we're glad to be back.
You're definitely Ringo.
Well, I was Pete Best in the last one, so. And I think to do this on Trump law is really important and timely, not just because of John's book, which is fabulous in terms of the way that it reestablishes constitutional norms, or at least tries to explain what the norms are supposed to be. This is obviously close to the front of my brain, because I've had a book out in the last year which dealt with what I think is a related issue, which is in our, not only our law, but I think our politics and our dialogue and our public debate. We've experienced over time the primacy of narrative over reality. And what I tried to address in Ball of Collusion was the fact that a political narrative was developed and it became sort of the national story and the national understanding about Trump and his purported relationship with Russia. And the most interesting thing about it to me, having gone through it very carefully, is how divorced it was from reality. In other words, when you had a combination of media people working with political activists and having what turns out to be really an effective partnership, although a sub rosa one in many ways, with officials in the intelligence community, what you were able to do was promote a reality that wasn't, or promote a story that wasn't reality, but became the public understanding of what this relationship was between the new president and one of our most challenging geopolitical competitors, to the point that even though now the Mueller investigation at the conclusion of it discredited the main part of the story, that is this idea that Trump was in a conspiracy, Trump and his campaign were in a conspiracy with the Kremlin to commit cyber espionage with a goal of throwing the election to Trump and away from Hillary. Though that's been debunked legally, and it's been debunked in terms of congressional hearings and the investigation and all that, when you poll Americans, over 40% of people still think that there was some kind of nefarious relationship between Trump and Russia, and that's how effective the story was. And the great thing about John's book, I think, is the popular understanding in America is that the Constitution is not what the Constitution is. The popular understanding in America, growing up, I think, over about a century now of progressive governance, which has been more and more strong and paramount in our society, is that there is a sort of a progressive constitution that has supplanted the actual one. And when Democrats and media figures and prominent scholars get up and talk about Trump, they talk about how he's destroying constitutional norms, not just presidential norms, but constitutional norms. He's shredding the Constitution. He's violating, with this executive order or that executive order, some aspect of the Constitution, when in reality, the norms that they're talking about are the progressive governance that's grown up over a century, this tension between what the administrative state that is engulfing us now versus what the framers' vision of limited government is. And what John's book, I think, is fabulous about making the point that the way Trump has governed is much more faithful to what the framers' idea of the presidency was than what we're currently experiencing, which is the progressive idea of governance. This was obvious in the Trump-Russia investigation itself, a lot of which is founded on this idea that the Justice Department and the FBI are supposed to be so independent of the political leadership of the executive branch that they are basically, in the eyes of progressives, an unaccountable fourth branch of the government, which to the framers' mind, I would say, if you were to divorce the police power of the government from political accountability, I doubt that the framers would have seen or thought of anything that was more dangerous or more of a path to tyranny than that kind of a combination. So I think John's done a real service in bringing us back to the planet Earth in terms of what the Constitution actually says, what our norms actually are, what the framers' vision of the executive branch was. and contrasting it to where we are now, because I think until you realize how far we've deviated from the path, you have no chance of ever getting back there.
Thank you, Andy. John, would you like to go next?
Yeah, great. Thank you. I'd like to thank the Committee for Justice and the National Review Institute for having us back. As Andy says, I think this is our second, this is like, what is it like? Is this our Abbey Road album now? And then we're going to move on to, by the end of the Trump administration, we're going to be on Sgt. Pepper's Lonely Heart. But it's great. It's great to do this. I hope we do this often, because I think the Trump years are really, and it's great to be with Andy. I love this book, Ball of Collusion. If you look at my book, which is on sale, it's heavily influenced by Ball of Collusion, because even though Andy wrote it, I think it came right after the conclusion of the Mueller report, I think Andy called it well before everybody else what was really going on. I think a lot of people didn't believe him at first, that there was this, the collusion wasn't Trump and Russia. The collusion was the parts of the Obama administration and this independent prosecutorial bureaucracy and the media. The more we learn about how the investigation got started, the more and more Andy's educated guesses turned out to be right, which is kind of scary, actually. And it's great to be with David, of course, who, from the other end, from the constitutional litigation perspective, has also called a lot of things right about this administration. And it ties into this bigger theme. I think all three of us are more wedded to a constitution as written, the constitution that the founders intended. And I think Andy's right, that what you see as attacks on Trump are actually attacks that he's somehow shredding a constitution that's been built up over the last 100 years, primarily in the New Deal or inspired by Woodrow Wilson. It's not really the constitution that the founders wrote. And so if you look at the attacks on Trump for shredding the Constitution, you look at what they say they want, his critics say they want to do in the next administration. They want to push the ball farther down the lane of this progressive Constitution, and to they attack what you call Trump law. It's really, I think of as 18th century Constitution law. So think about what his opponents want to do. His opponents want to get rid of the Electoral College because it gives states too much power, or because somehow it's inherently racist. They want to pack the Supreme Court because they don't like the fact that the court is interpreting the Constitution in an originalist manner. They would like to, Andy talks about in his book the defects, and we've talked before with David about the perils of an independent counsel. They would have more independent counsels. They've actually proposed restoring the statutory independent counsel. And there are people who say, let's make the FBI independent, fully independent, like the Federal Reserve, or let's make even the Attorney General independent. They want to nationalize more of the economy in the Green New Deal. They'll nationalize transportation and energy sectors, which would make Obamacare just look like spring training compared to, it's his critics, I think, that actually want to push the country towards even farther down this progressive vision of governance, but one that's not faithful to the original Constitution. So that leaves Trump in the position. I think intentionally or unintentionally, consciously or unconsciously, Trump is the one then who is protecting and guarding the traditional written Constitution. And so he could, just by winning in 2016 or winning in 2020 and just not going along with this agenda, he's done, I think, some good, but I think also look at what he's done, I think, in an affirmative way by defeating the Russia collusion investigation. What he did, I think, even though he's, again, accused of violating constitutional norms, he's actually restoring the written Constitution's vesting of the executive power and the power of law enforcement in the president. Right? It's only the president that has the power to take care the laws are faithfully executed. Everyone who works in the executive branch on law enforcement is an assistant to the president. I think the founders would have been shocked at the idea that Congress could somehow shield parts of law enforcement, prosecutors, or the FBI from presidential control. And it is, I think, a fundamental conflict between this idea of a politically accountable executive who can then control the bureaucracy, or the idea of an insulated, independent bureaucracy that's free of control by anybody. And you can see Jim Comey and the FBI, they thought they were independent. They could choose who was worthy or fit to be president rather than the voters. Similarly with impeachment there, I think impeachment is another example. Here you have a foreign service, which does consider itself also independent and expert. And they were deciding what's the right way to conduct diplomacy? What should the positions of the United States be? Regardless of what the elected leader of the government yielded by the Electoral College and the 2016 elections thinks. They wanted to remove him from office, even though the founders thought that really should be elections. Again, political control of our elected officials, that would be the main check for any kind of abusive executive power. And then the last thing I'll say, and then turn it over to David, is foreign affairs. This is really interesting. This was a hard part to figure out, is what is the Trump doctrine? And so most, I think, progressives, even though it's interesting, they love the concentration and centralization of power within the agencies when it comes to domestic affairs. And foreign affairs, they don't like the president having a great deal of authority. They try to claim the Declare War Clause requires congressional approval for all uses of force, that Congress has to approve all international agreements, and so on. The thing that's interesting about Trump is that he's done the opposite of what a lot of presidents have. Rather than expand engagements abroad, he's withdrawing troops from Syria. He's trying to draw them in Afghanistan. He's drawing them down in Germany. Rather than enter lots of agreements, he's been terminating agreements. The TPP, the Iran nuclear deal, the Paris Accords, the INF deal, the Open Skies Treaty. And I think that actually shows in the end that the president really was constitutionally in charge of foreign affairs and national security, because there's nothing Congress can do to stop him when he chooses to use those powers to withdraw the US from a lot of overcommitment abroad rather than to expand them. And I think it shows the hollowness of the attacks on presidents in the past, that they didn't have this kind of primacy in foreign affairs. So again, I think the one thing is, and then we can talk about this, the one thing I think has been raised again by all this talk today in Washington about, can the president issue executive orders to stop collecting taxes? I think that's a great example of Trump law, because President Obama said, I'm not going to enforce the immigration laws. Right? David was part of the litigation against President Obama. I agreed with him. I think Congress is the one that sets who gets to stay here, how many people get to stay here. President Obama, so I'm going to create a new category of legal residents by not enforcing the immigration laws. I don't recall our progressive friends saying, that goes too far. That's a violation of presidential power. When the Supreme Court just a month ago upheld that and said President Trump has to take years to undo President Obama's act, even when President Trump thinks it's unconstitutional, I don't remember our progressive friends saying, oh, the Supreme Court's wrong. Right? How could that be? How could one president not be reversed in the exercise of prosecutorial discretion by a subsequent president? But all of a sudden, when President Trump says, I might use that power to change immigration law or to reduce taxes, all of a sudden you have progressives saying, that's unconstitutional, that's outrageous. That's a great example of this idea, I think, that progressives or Trump critics have, that there's a constitutional law that only applies to Trump, and there's a constitutional law that applies to everybody else. And that can't be right. Thanks a lot. I look forward to hearing David's thoughts. And thanks, Andy. Thanks, Curt.
Thank you, John. David, it's your turn.
Thank you very much. It's a pleasure to follow two good friends, two great books, both of which I enjoyed reading. One disadvantage of following two great friends who are very much like-minded is that most points have already been made, but I'll ring up the rear and talk about a couple of things. Look, Andy opened up by asking how much of it is of Trump law is sort of unique to Trump and how much it reflects some more fundamental deformation, shall we say, of our constitutional strictures. I think it's an interesting melange. You do have both, and the balance depends upon the issue. There's a simple matter of litigation expediency, on which John just commented relative to the issue of litigating DACA, because you don't need to be a pedantic litigator to realize that it's passing strange if the basis of DACA is the exercise of prosecutorial discretion, which ostensibly it was. It's not, as John explained in some detail in his excellent book. Prosecutorial discretion does not encompass a wholesale refusal to implement a particular set of laws or a particular portion of a law. In the framing period, that was called a dispensing power, which emphatically was a very controversial issue in British constitutional history, and emphatically not what the framers meant for the president to have. And by the way, again, as John mentions quite correctly, in the DACA case, it wasn't just a wholesale abdication of the enforcement of INA, Immigration and Naturalization Act, with regard to a large identifiable group of illegal aliens. They also gave them work authorizations. And I don't know how that can even theoretically be prosecutorial discretion. It's like somebody's saying, for example, I'm not going to enforce any traffic tickets and also going to give you $5. The $5 part really does not work. But so as John points out correctly, how is it possible that you need to follow strictures of Administrative Procedures Act to undo the exercise of prosecutorial discretion? But that to me is essentially a matter of, let's call it litigation expediency. There are a number of things that are unique to Trump. You know, for example, we've had debates going back centuries to the Pacificus and Havidius debates about the role of the president in directing foreign policy. Is the president merely a titular head of the executive branch when it comes to foreign policy, and how much power does Congress have? What's a little unique here, and I think it's important for our listeners and viewers to appreciate that, I could be wrong, but I'm not aware of a notion that when it comes to foreign policy, the proper driver is not so much Congress, but the permanent bureaucracy. I mean, that issue that it's really the NSC staff, it's the State Department, maybe a portion of the Defense Department, and to a certain degree, the intelligence community that drives our foreign policy. I mean, that's fairly new. That's not something I've seen in the previous battles between two political branches. So that's a little bit about that's unique to Trump. But I certainly agree with a basic proposition, and it's interesting. I mean, John makes a very elegant point in his book, which is very dear and near to me, which is, look, what is happening now is a stress test of a constitution. And the overarching way to enforce the separation of powers, the framers believe it's ambition counteracting ambition, precisely because this president has been under assault from even before he took office. When he ran for president during the transition and during his entire time in office, he had to fight back efforts against him, both by portions of, I hate to use this term as certain connotations, the deep state, as well as Congress, as well as media. And what did he have to use to fight that? It to marshal the resources of executive branch. So in many respects, this president has done more than anybody else. I'm sure he would have preferred not to be in that position, but bring vigor, bring dispatch, despite all the criticisms about how messy his decision-making is in the White House and all the change in personnel. He really, to an unprecedented degree, had to push back against the efforts, both within the executive branch to usurp his prerogatives and by other branches, be it judiciary, because God knows there's resistance to Trump in the judiciary as well as Congress. So it is actually a remarkable experience, remarkable experiment in the restoration of a constitution. I'll close on a slightly pessimistic note. Yes, a lot of it is expediency, but the problem is not going to go away. A lot of law was made in a process of trying to take down President Trump would unfortunately endure, despite the fact that the Supreme Court almost, I don't want to say invariably, but in large measure struck down some of the more egregious exercises. Now, why is that? As a practical and pragmatic litigator, I can tell you, just because the Supreme Court takes something down does not completely vitiate the impact of bad decisions at the district and circuit court level. So, for example, mentioning the whole saga of immigration executive order, yes, the Supreme Court has disciplined both the Fourth Circuit and the Ninth Circuit. It came to various iterations of executive order and done it fairly brusquely when it comes to such things, if you follow how the Supreme Court expresses its views. But I would bet you anything, there's a lot of your articles, there would be briefs in the future citing the somewhat idiosyncratic, to put it gently, views of a Ninth and the Fourth Circuit, particularly the notion that you can look behind the four corners of what is clearly a legitimate exercise of statutory and constitutional authority and look at the president's personal motivations, particularly when it comes to foreign policy. So I'm afraid it's going to be with us for a while. Thank you.
Thank you, David. Let me follow up with what you were saying about DACA. And you're right, it's absurd that we went from President Obama saying that he did not have the power to bypass Congress and implement the DREAM Act to him saying, well, I can do it through prosecutorial discretion, to now the Supreme Court saying, you know, it's so etched in stone that unless you follow every little corner of the Administrative Procedures Act, you know, you can't overturn it. So, but, you know, it's not just DACA. I mean, we saw it with the census. Courts have been enjoining Trump's executive actions right and left. Am I missing something? I mean, it used to be that executive actions challenging them under the APA was a Hail Mary pass because there was so much deference given to the executive branch, and now it seems like it's almost the opposite. I mean, is that right?
Let me just say briefly, it is indeed a new practice. I mean, look, I practice a lot of regulatory law for a living that challenges, APA challenges to the way agencies exercise the statutory authority have been delegated to them under various statutes is well known. Applying it to executive orders is indeed remarkably unusual. I would say, again, of the two egregious examples you mentioned, the census, while I think the Supreme Court was wrong, it was not about motivations, thank God. It was about the pretextual nature of the explanation proffered in the position finally arrived at by the Secretary of Commerce, because God forbid there was some interplay in the interagency process where somebody who opposed what the Department of Commerce was doing felt it was pretextual. I can assure you that that kind of snarky language is ever present after many years in the federal government in every regulatory battle. That was bad. But frankly, DACA was worse because I don't see, again, how if it's really was exercised in prosecutorial discretion, how APA applies. And by the way, how is that an insufficient explanation if you think that something that you are doing exceeds your lawful authority? I mean, it's stunning. But you know what? Despite those two examples, he's done well on a number of other executive orders. So his track record with the court is not bad. My problem, despite some aberrations, is not with the Supreme Court. My problem is, frankly, with a large body of judiciary that includes at least 3 different circuits and numerous district courts that absolutely do not follow the rule of law.
Well, you're right. The Supreme
Can I
Court
follow up on David's point there?
Sure, go ahead.
Yeah, I was going to explain that actually I would put it a little bit more pessimistically in this sense, is that one, I think, story that we have all touched on but hasn't been really written about that heavily is that one institution that has taken advantage of Trump to expand its power has been the Supreme Court and the federal judiciary. And I think the DACA case is a good example. So you would have thought that under the traditional understanding of the Constitution, each branch has the right to interpret the Constitution for itself when it performs its own duties. So I think that's the view going all the way back to the Federalist Papers and Jefferson, Lincoln, and so on. So here you have President Trump. He comes into office. He legitimately thinks that President Obama, I think as all of us have suggested, was violating the Constitution, was failing to do his duty to take care the laws were faithfully executed when he put the DACA program into effect. So President Trump comes into office and he says, I'm stopping DACA, not because I disagree with the policy. He actually says he's in favor of a DACA solution, but because I think the program's unconstitutional. And look what happened in the DACA Supreme Court case. The Supreme Court case said that is not a legitimate reason to stop a program. So in other words, the Supreme Court said we have the power to force the president to continue doing something he believes is unconstitutional. Right? That is, I think, a stunning claim of judicial supremacy. And I think that was also involved with Hawaii versus Trump, the Trump travel ban. Even though Trump won, remember at the back end of the opinion, the court said, as David suggested this too, we have the right to rummage around in presidential motivation to see, we're not going to respect the facial explanations given by President Trump for the travel ban and national security. We have the right to look and see what his real motives were. Now they said they were satisfied, that they were okay, but it's as if the president said, well, I'm not going to take facially what the Supreme Court says as opinion, as its good faith reason. I'm going to find out what Justice Ginsburg was saying to the press during the pendency of this case. So I think one thing, and this is something I'm afraid even conservatives on the court have not always opposed over the decades, is that this Roberts Court really believes it's a supremacy in interpreting the Constitution. And in these Trump law cases that you call them, Curt, what it's also been doing is saying we get to impose our vision of the Constitution on top of or in opposition to the president, and we don't respect the idea that the president or Congress has the right to interpret the Constitution too.
If I can just add one 10-second point. Interestingly enough, if it came to the merits, I would make an educated guess, but would have gotten 5-4 on DACA, as well as on census. How do we know that? A little footnote, after Justice Scalia died and we had a justice in the Supreme Court, some of you may remember DAPA, which is fundamentally a larger, grander version of DACA, legally no different, was stopped by the Fifth Circuit, by the District Court, and the Fifth Circuit went to the Supreme Court, and it was 4-4. So obviously, it did not overturn the Fifth Circuit, but I very much doubt that the Chief Justice would have reached a different conclusion. So here we have a procedural gambit to avoid reaching the merits in both instances. Regrettable. I mean, it really is almost palpably political, and for a Supreme Court to play politics, no matter in which direction, does not enhance its legitimacy, in my opinion.
Now, of course, the reason that those went 5-4 the wrong way was Roberts. Is Roberts guilty of some Trump law himself?
Well,
that's for all of you.
I would just jump in on this in terms of, I think the problem here is the Supreme Court, and this is not unique to the Supreme Court, but it's fatal to the system. The Supreme Court deciding that other considerations besides what the law is are the compass by which it makes its decisions. I think it's not just the Supreme Court. We saw a little bit of this, for example, when Attorney General Barr tried to testify. No one recall their time on me, please. But remembering when he was the few times that he got a chance to weigh in, he was asked a number of questions about the Obamacare litigation and the case that's up before the court now. Now, I happen to disagree with the position the Justice Department has taken. I think that the mandate was severable. I don't see any reason why the whole act has to go. The not so subtle read that you get is that was probably the advice that the Attorney General gave to the administration, and they decided that they were going to take the position that the whole act had to go. That's a legal debate. But the interesting thing that was going on in the Senate was they kept saying to Barr, but what are you going to do if the act is unconstitutional? Like, we're going to have people who don't have coverage, and we're going to have, X, Y, and Z other catastrophic things. And Barr kept looking at them with this sort of puzzled look on his face and said, I'm the law guy. My job here is the law. You know, the answer here is what the law says it is. And you guys, you're Congress. So if there's like a hole in the edifice and it's got to be patched up, that's your job. But my job is to say what the law is. I think the Congress won't do that anymore when it should. And what the Supreme Court seems to be telling us is that, or at least what Chief Justice Roberts, I think, is telling us, is that the reputation of the court as a nonpartisan entity and projecting that in terms of what the court's integrity is more important than what the legal answer to whatever question is in front of the court is. And therefore, we're making decisions based on what the media says and what the headlines say and what the Democrats are apt to say if we give a faithful constitutional answer rather than the Constitution is our barometer.
Is that a proper concern for a Chief Justice, or should he just be following the law just like the other 8 of them?
I agree with Andy's point that the only way to explain what Roberts is doing is political. I think David made that same suggestion. I would point to yet another case other than DACA, which is the most obvious one, but the Louisiana abortion case where the Chief Justice actually just voted 4 years ago that a virtually identical law out of Texas was constitutional. And then he, I think inexplicably voted to strike down the same law because it came out of Louisiana, and then gave a very, I thought, lame justification that this was demanded by stare decisis for a decision that was just 4 years old, that affected very few people, that had seemed not to create any reliance interests, that he himself then in his concurrence actually didn't follow in terms of its reasoning, only its result. Why is he doing this? I think he is doing exactly what he did with 2012 when David was suing him up and down for Obamacare. Not suing Roberts, but suing on Obamacare, which is he's trying to render decisions that reduce the political profile of the Supreme Court during an election year. I think he's responding to the obvious pressure that critics are putting on him. The problem, I think this is just Andy and I agree with it, is that just means that critics are going to do this even more to the court and to Roberts because they know it works. I think that they put a lot of pressure on the court because of the abortion case, because they saw it worked in 2012 when Chief Justice Roberts allegedly flipped his vote on Obamacare because of threats coming from the Democrats in the Senate and even from the White House. Remarkably, so during the pendency of the case, not after it was over, but while the court was deciding it. And so I'm sure Chief Justice Roberts is watching as many, if not, I think I would say most of the Democratic primary candidates said that they supported the idea of increasing the size of the Supreme Court to 15 justices. And second, I think sometimes Roberts or sometimes justices, they buy all the hokum about Chief Justice Marshall being some great judicial statesman and navigating the court politically through the shoals of the early republic and fending off attacks by the Jeffersonians. Whether that's true or not, sometimes I think that justices believe their own press about that. And that, I think I agree with Andy, that opens up a dangerous Pandora's box because of what is not a suitable ground to decide a Supreme Court decision on.
I would just add one sentence. I know it's don't need to be piling on a very good lawyer and a very fine Chief Justice overall, but whatever may have been necessary to shore up the court's legitimacy during the founding era is not required anymore. The court's legitimacy is well established courtesy of Chief Justice Marshall. And I do agree with what John explained it well now and in the book. The appetite comes with eating. If you're going to act politically, by the way, the only good thing I can say, this is not part of Obamacare because as John points out, the challenge to Obamacare occurred during the Obama administration, so nothing to do with Trump. But it's the same type of a decision. It's perceived need to avoid taking a very politically contentious decision. Understandable temptation, but acting politically is the last thing any Supreme Court justice, or for that matter, any member of Article 3 should do.
I want to get back to impeachment. as you've all mentioned, the president's critics say he's guilty of many, many crimes, certainly under Trump law. And but to the best of my knowledge, no crimes are actually cited in the articles of impeachment. Does that pretty much answer the question about whether there's any there?
No, I don't think so. I think what's happened is, to my mind, the framers put impeachment in with the expectation that it would be Congress that would discipline a wayward president. And the founding documents are clear that a crime is not required for purposes of impeachment. Over time, what's happened is that the Congress, which doesn't do much of anything these days other than go on cable television and complain about how bad everything is, they basically delegated to the executive branch, which I think the framers would have thought was preposterous, the investigation of the executive branch. And it was for that reason, I think, that the Mueller investigation, which was a proxy more for a congressional oversight and impeachment investigation than necessarily a criminal law investigation, had very extravagant ideas about what it was investigating. And I think the most extravagant one, and this was the most relevant one, because I think once Mueller took that investigation over in May of 2017, it was mainly an obstruction investigation. I think the collusion thing had pretty much collapsed by then. But their theory of obstruction, which goes, I think, to what a lot of what John is talking about in the book about the accountability of the executive branch, and what the idea that all the executive power is in the president and everyone acts as a delegate of that power, right? Their idea was that an inferior executive officer, a federal prosecutor, could second guess and find corruption if the chief executive exercised his constitutional discretion in a way that was ostensibly lawful, if the inferior officer later on decided that it was corrupt. I think the framers would have thought that was crazy. And yet, that not only was the norm of this investigation, I think had Attorney General Barr, who was very clear that he was not on board with that theory of obstruction, I think if he had not come on board, there may have been a very different ending to the Mueller investigation and to how that all worked out, because I think that was their theory of obstruction, and they would have run with it if they hadn't been stopped.
I can just add one point, and I agree with Andy. The same concept permeates the entire impeachment. We can spend a couple hours talking about it, but just to summarize, the view of what is an impeachable offense, as expressed in the House Judiciary Committee report. The exercise was largely driven, of course, by the Intelligence Committee, but at least some legal scaffolding was provided by Judiciary Committee, is that, and I only slightly paraphrase, but just like with what Andy is talking about relative to Mueller. So if you are doing something that is entirely legitimate standing alone, you are committing an impeachable offense. You're acting corruptly if you are also doing it to benefit your political interests. There have been many disputes during the founding generation about 100 different issues, but I don't know of any framer, indeed any member of the founding generation would have said, if a member of legislature or judiciary or the executive is exercising his or her power and it's entirely legitimate, because I can make an argument that that particular exercise, and it would work for judges, we're not talking about money. If you're writing a decision which is entirely within your authority, but you're doing it because you want to preen, you want to get accolades from the media, you want to go down in history. And if you're the president, you want to enhance your popularity, you want to be reelected. But that someone transforms an impeachable offense. It's not even ridiculous, it's insane. It is absolutely insane, and I wonder, I've written several op-eds at the time, if members of a legislature pondered for a second, how would it feel if that law applied to them? Okay, well, I mean, there's disputes. Obviously, members of a House are not subject to impeachment. There are some disputes about whether members of a Senate can be impeached. But in general, members of the legislature all the time take positions, pass bills, appropriate money in ways that, we're not taking cash. They don't ask their political interest. So if you apply in essence, in a democracy, if you disqualify exercise of power because they happen to coincide with their political interest, nobody will be able to exercise any power. Certainly neither of the two political branches at the federal level or anybody political branches at the state level. It's insane, totally insane.
You just maybe draw more, just a different point on impeachment, but I agree very much with what Andy and David have said, which is you often heard the argument that President Trump is somehow illegitimately defending himself from impeachment because it's in his political self-interest, or that it was wrong for the Republican senators not to convict because it was in their political self-interest. And one thing I think the Constitution does with the presidency, but particularly with impeachment, and particularly with Trump, is that it expects people to pursue their political self-interest. The system doesn't actually work unless, in their view, unless each branch is pursuing their rational self-interest. As David said, then ambition counteracts ambition. And there's a reason why the founders did set the removal vote requirement in the Senate at 2/3, because they were exactly worried that a partisan House would impeach presidents just because they wanted to control them. And the founders realized the power to remove was the power to control. And one thing we know they didn't want was a prime ministerial system, a cabinet system where the House basically controlled the chief executive. Otherwise, we could have just adopted a British parliamentary system. And so I think Trump, right, so Trump, he was angry about being impeached, and he thanked his supporters. He also said thank the framers, because they were the ones who wanted him to win. Right?
A question for all of you. If Trump is reelected, will the House impeach him again?
Probably not till March.
Well, I think that how about this pessimistic prediction? I don't mean to depress listeners. I think we've seen nothing yet. I expect horrible behavior surrounding the elections, particularly when it comes to the functioning of the Electoral College and various other things, but that's for another time. I would expect, jokes aside, in our impeachment efforts, because that's a good way to try to incapacitate the administration. And they're going to try it again. I don't know how much of it's interesting. All three of us agree that accountability, which is a fancy word for describing paying political price when you do wrong and getting political benefits when you do right, is the lifeblood of the separation of powers in the entire constitutional system. My fear is that the House Democrats have not paid much of a price, if any, for this impeachment. So why shouldn't they try again?
Yeah, the serious point I would make about this is that the smarter people among the Democrats in Congress knew that impeachment was a bad idea and it might actually blow back on them and help Trump, and yet they were unable to stop the train once it started. And I think part of that is maybe because it was an election year, and what inevitably, in a presidential election year, whatever inevitably happens is the base pulls the people who are speaking most for the party, namely the presidential candidates, further and further to one side while the contest for the nomination is working itself out. And that puts pressure on everybody to get over there. So Trump became so toxic as far as that contest was concerned, that even if you thought that impeaching him was a bad idea, you couldn't say that out loud. But even in a non-election year, I think a lot of those pressures will still be in place. So I worry that the more wise people who see the downside of this won't be able to stop it.
Go ahead, John.
Oh, just 2 points. One is it's if Biden were to win, it's not just Trump. Trump they talk about impeaching Brett Kavanaugh, too. Several of the presidential candidates for the Democrat. So it won't just that will Trump will not be the only target of impeachment, I'm afraid, in the next 4 years. And then the second thing I would point out is that I was just unsure about, but I think a lot of the complaints about Trump and a lot of the investigations that are still going on have now turned to Trump before he was president.
Yep.
The Russia collusion investigation is theoretically an investigation of him before he's president. This investigation that's going on in New York by the Manhattan DA about it, that was just announced this week about money laundering and so on, or fraud by Trump. Again, that's also things allegedly Trump did as a private citizen. I don't see why constitutionally the impeachment clause applies to things that people did before they were president. Impeachment is for removal from office for abuse of power of the office. And these were all things that, right, if Congress is allowed to expand the impeachment power to say, okay, we didn't get him for Ukraine, but let's impeach him because when he was head of the Trump organization, he did that seems to me would be a huge aggrandizement of Congress's power over the executive, and one the founders would have rejected.
Well, John, you mentioned the New York AG going after him for things that have nothing to do with him being president. Do you think that even after he's out of office, whether it's a few months from now or 4 years from now, he's going to continue to be hounded, or will there no longer be much political gain in doing so? And when I say continue to be hounded, not so much by Congress, but by all these individual left-leaning prosecutors.
Well, I defer to Andy, who's no doubt had to fight with the DA's office in Manhattan for much of his career. Not as a defendant, but as a, an assistant U.S. attorney in New York City, where, I'm sure that you fought all the time with them on jurisdiction over cases. But if that's the case, at least that's what the Constitution seems to suggest, right? Constitution says, and the Federalist Papers say, you delay these criminal actions and investigations of a president until after he's impeached or he leaves office, and then he loses his immunity.
Yeah, I would just say on venue, it was mainly the Bronx DA's office who was after me personally, but quite right. I was in, plenty of turf battles with the Manhattan DA. I think the tendency when you get a president out of office is to move on. I know it's the tendency, obviously, when it's a Republican that takes office after there's been a Democratic scandal. I personally experienced it as a prosecutor when we were investigating the Clinton pardon scandal as the Bush administration came in. And I can tell you the Bush Justice Department didn't want any part of that investigation. I think that's usually the way things work. But we're focused on the impeachment clause. I wonder if there won't be a big push to get the Justice Department to revisit the guidance about whether a sitting president can be indicted or not. It's very difficult, obviously, to impeach a president, and for all the reasons John mentions, even if you can get over the political hurdles, there's the legal question of should it apply to things that you do before you get to office. But of course, that doesn't apply at all to criminal prosecutions, and particularly criminal prosecutions by a state, which isn't even under the federal jurisdiction.
I'm probably the most pessimistic person on this panel. My prediction is that Trump has provoked, evoked, triggered, whatever one want to use, such level of hostility that state and local prosecutors will go after him after he's out of office, and it's going to be difficult and painful. And I very much doubt that you can find a fair jury in New York on the issues raised by the Mazar's case and whatnot. So I don't, and obviously president, I think the president can pardon himself. I think pardon power is absolute. Can only pardon for offenses against the United States. So I don't think there's any serious argument to be had that you can pardon yourself for alleged offenses under state law. So the level of partisanship is only going to get worse, I'm sorry to say. So it's going to be, fasten your seatbelts.
Let me try to get in at least one audience question here before we run out of time. A few people have asked about Operation Crossfire Hurricane, the investigation of the Trump campaign and Russian officials. And let me tie it to what we've talked about earlier, which is that accountability for wrongdoing ultimately is what makes democracy possible. Will the folks behind the Russia investigation ever be held accountable by Durham or anyone else?
I just think there's all kinds of, there's all kinds of accountability. It's not necessarily accountability by prosecution. I would suspect that the people who they have a ironclad case on for either manipulating evidence or tampering with evidence, like that FBI lawyer allegedly did, and for making misrepresentations to a court, I think those kind of cases can be brought. But Attorney General Barr says he wants no exotic, extravagant theories of prosecution like Andrew Weissman's, conspiracy against the United States, which is endlessly elastic to capture anything Congress hasn't gotten around to criminalizing yet. He talks about meat and potatoes prosecutions. I don't think you're going to get that against the upper ranking people. And that's probably why he's talking about a narrative report as well.
I happen to agree with Andy. I think it's regrettable. I think in good faith, one could come up with theories of liability that reach, and I'm not talking about the president or the vice president, but can reach within senior levels of DOJ and FBI. I'll tell you, what depresses me, there's only one thing worse but not discovering tremendous abuses of power, is discovering those abuses, amply documenting them, and really allowing the responsible people to go free. I would rather we haven't discovered that. So it remains to be seen. But one thing is clear: if Vice President Biden were to win, whatever prosecutions have been initiated will not be sustained. I don't think that in that environment, DOJ would have any problems, which is, by the way, as Andy knows very well, is highly unusual. But I served in the Reagan-Bush administration when we inherited not even criminal, but civil matters, which we disagreed as a matter of policy. DOJ would not go back and try to pull it back. I don't expect such fortitude from the Biden administration if it happens to come in.
In other words, the Trump law doctrine that the Attorney General should not interfere in the Justice Department would quickly go by the wayside.
Correct. I think you're going to have a very centralized Justice Department instead of letting individual prosecutors. Anyway, Andy can talk about it better than I can.
Well, we've talked a lot about what Trump has had to endure as president, and then we hinted at what he may have to endure after he's president. Is that going to mean that Trump is a one-time phenomena? He's done his best to push back against all these attempts to politicize the law, and he's been at least partially successful. But will anyone want to take on this battle again? After what Trump has been through?
I think this is sort of the ending message of my book, was that Trump has used the Constitution mostly as a shield. He's been on defense almost his entire first term. As all three of us have said, just wave after wave of attacks on his legitimacy. It's almost like he never had a chance to put forward a positive agenda. And so you would think, even though Trump might feel that he's been battered for 4 straight years, it's almost as if his presidency never really got off the ground, which might have been the whole purpose of all this in the first place. And so I think there's the pitch I would make is that, one, just by doing that, he did a great service by protecting the prerogatives of the president. Whoever comes next, if it's him or somebody else, they'll have the powers of the office. And we won't have, I think, another 4 years of defense. But then I think the great challenge, I think, is still the one we start out with, is you still have the problem of a gigantic, powerful, unaccountable bureaucracy that clearly does not know how to adapt to the 21st century world. And that's really the project, I think, of the future presidents, is restructuring our government to make it more accountable, but also to allow it to grapple better with this new economy. That's what Trump, I think, or would do in a second term if given a chance. I fear, and this I think that was Andy's point too, that if Biden were to win, we're just going to have more progressive government, which is I think just is becoming obsolete and failing us in this new economy, in this new society we have.
Gentlemen, Andy or David, any comments on whether we'll see another Trump?
Let me try to take a stab at it. It's a political prediction, not a political pundit, but I would say that actually, particularly if Biden were to win, we are going to see somebody who would be Trump on steroids, because the real reason Trump won was not because he's lacking in political skills. He's actually an unorthodox but quite skillful politician. It's because there's tremendous level of disenchantment across the wide range of American people with governance. And I'm a Republican, served in two Republican administrations, but I would have to say we're both Republican and Democrat presidents. So populism is fed by genuine disenchantment. Sometimes takes an ugly form, not always, but it's fed by genuine disenchantment. Give us 4 years of Mr. Biden. I think that it's very possible that you would have somebody who would make Trump look tame.
I just would add to that it's so hard to predict. 6 years after Watergate, we had President Reagan, and I don't think anybody would have predicted it at the time of Watergate. So whatever happens with Trump, and as sui generis as he seems to be, if we get a Biden administration, within weeks, they're going to do something that's going to change everybody's perception of what it is we're dealing with in the now, and it'll make Trump seem like further in the rearview mirror. The precedents that get set are still going to be applicable, so they're still important. But I just think these things are driven by events more than anything else.
Well, I'm afraid we've run out of time, and with you three, we could always use more than an hour, but I know you're very busy, and I'm glad you're able to come back together for this second panel, or as John might say, the second album. I think it was another great one. It would not have been possible without three such great guests, and I hope we can do it again soon, a third album, so to speak. And thanks again to National Review Institute for co-hosting.
Thanks.
Thank you.
Thank you, everybody.
Are we still on? Pleasure to be with all of you.